Aloha and welcome. Good afternoon. This is a joint hearing of the Senate Committees on Government Operation and Health. Today is Tuesday, February 15th at 3 o'clock p.m. I'm Sharon Moriwaki, chair of the committee. Joining me today is Vice Chair Dela Cruz, Senator Favela. I don't know if I have any other members. Senator Chang, aloha. And with me, co-chair Senator Keoho Kalole from Health. Oh, Senator Gabbard is also on. Chair Keoho Kalole.
I'm here with Vice Chair Baker, Member Senator Moriwaki, and Senator Favela.
Okay. Before proceeding with the hearing, I'd like to make a few housekeeping announcements. The hearing is being streamed live on YouTube. You can find links to viewing options for all Senate meetings on live and on-demand video page of the legislature's website. In the likely event we encounter major difficulties during the hearing, the committee will reconvene to discuss any further business on Thursday, February 17th via video conference. And because of our recording and this long hearing, we have only 90 minutes. We're going to try to keep it down to 2 minutes per testimony or testifiers who are on. For this hearing, it is a decision-making hearing on a measure heard on February 10th, so we can go pretty quickly. Senator Keoho Kalole, are you ready to go on it? Okay, this is SB 2137 relating to transitional housing. It was to establish a public informational meeting for a county permit to operate a halfway house, clean and sober home or drug rehabilitation home, and for the clean and sober registry application. The chair's recommendation is to pass with amendments, deleting the sections requiring informational meetings for a transitional housing permit and for a safe and sober home registry application, and replacing it with education of the public on safe and sober homes and procedures for filing and resolving complaints so that it will be non-discriminatory. Specifically, it deletes section 1 in its entirety, which has to do with informational hearings. In section 2 of the bill, we have added, in addition to the department establishing a toll-free telephone number, that the department and the counties that also receive complaints shall work together to resolve problems and complaints received by the state or county, and the department shall educate the public on clean and sober homes, on the registry, on the state and county complaint procedures, and on their contact numbers. And we'll delete sections 7, M, and N, and delete section 3. Any questions, members? If not, the chair, government operations on SB 2137, chair votes aye. Vice Chair Dela Cruz. Oh, you have a question?
Yeah, Can we just call a short recess so I can go grab the vote sheet?
Oh, okay, sorry. Yes, please, short recess. Okay, so the Government Operations Committee voting on SB 2137 passed with amendments. Chair votes aye. Vice Chair Dela Cruz.
Okay, SB 2137 recommendation is to pass with amendments. Chair votes aye. Vice Chair votes aye. Senator Chang.
Aye.
Senator Gabbard.
Aye.
Senator Favela.
Reservations.
Okay.
Recommendation adopted.
And passing gavel over to you, Chair Keoho Kalole for Health.
Thank you. For Health Committee, same recommendation, passing with amendments. Chair votes aye.
Vice Chair votes aye. Senator Moriwaki.
Aye.
Senator Sam Buenaventura. Senator Sam Buenaventura, excused. Senator Favela.
Reservation.
Chair, your recommendations adopted.
Thank you.
Thank you. This adjourns the joint hearing. Thank you for your patience. Aloha. Okay, we're going into GVO committee now for decision-making on the 305 agenda. This is decision-making on Senate Bill 3034, previously heard on February 3rd, and it has to do with joint contractors or subcontractor listings. It clarifies the listing of joint contractors and subcontractors required for construction bids. The chair's recommendation is to pass with amendments to clarify who should be listed on the subcontractor list under sections 103D-302. The problem was brought to our attention by the State Procurement Office that the term joint contractor is not included in Chapter 444. And this amendment corrects that and clarifies it by removing the word joint from joint contractor in the bill and using instead contractor, which is used in Chapter 441, and includes any person who, by oneself or through others, works in connection therewith, meaning it's joint contractor, but it doesn't use the term joint contractor. So it's that amendment clarifies that we are covering joint contractors by that term. So, members, any questions? Discussion? If not, chair votes aye. Vice Chair Dela Cruz.
Okay, Senate Bill 3034, recommendation is to pass with amendments. Chair votes aye, Vice Chair votes aye. Senator Chang,
Aye.
Senator Gabbard,
Aye.
Senator Favela,
Reservation.
recommendation adopted.
Thank you. So that adjourns that meeting, and we are now moving into the GVO agenda of 3:10 p.m. The first on the agenda is Senate Bill 2111, relating to public notices, allows government agencies to post legal notices on an electronic calendar on an official website. And we have testifying on Zoom, the Department of Health.
Not present, Chair.
Yes. Aloha.
Not present.
Not present, okay. Next is Department of Human Services.
Good afternoon, Chair, Vice Chair, and the members of the committee. Nimari Hall, Department of Human Services, Policy Director, testifying on behalf of Director Beth. DHS stands on its written testimony in support of this measure. Thank you for the opportunity to testify.
Thank you. Department of Land and Natural Resources. Anyone from DLNR? Okay, in support.
Hello, I'm here.
Hi. Oh, okay. Hi. Pua.
Pua Ayu from the Department of Land and Natural Resources. Sorry, I was a little bit late. We are testifying in support of this bill and will stand on our written testimony. Thank you, Chair and members.
Thank you. Next, City Department of Planning and Permitting. In support. National Federation of the Blind, James Gashel.
Thank you, Chair, Vice Chair, and members. James Gashel here, National Federation of the Blind of Hawaii. We support this bill, but request an amendment specifying that the format of which notices are posted in must be a screen reader accessible format. Some of us read with screen readers, not screens. I'm one of those people, so we particularly want this amendment, and I'll stand on the written testimony, and thank you very much.
Thank you. Next, Oahu Publications. In opposition, Lori Lum?
Yes.
Yes. Hi.
Good afternoon,
Aloha.
Chair Morawaki.
Yes.
Trying to get my camera working, but good afternoon, Chair
Oh, good.
Morawaki,
Good afternoon.
Vice Chair Dela Cruz, members of the committee. Lori Lum on behalf of Oahu Publications. We respectfully oppose this bill. We publish 4 of the 5 daily newspapers in the state, including the Honolulu Star-Advertiser, the Garden Island, Hawaii Tribune Herald, and West Hawaii Today. And we believe this bill is unnecessary as we already have all legal ads on our 4 websites. The total combined monthly views per month is over 28 million. And anyone can view these ads, so not just subscribers. You don't need a password or a subscription to view them. Requiring another website for legal notices maintained by the state or a county which will incur costs and resources, we believe is duplicative, and we question whether it also will reach the largest possible audience. Further, many kupuna across the islands do not have access to electronic platforms and may not be properly served, as legal notices are already reaching the largest popular audience, both in print and digital platforms. We ask that you consider holding this measure. Thank you for the opportunity to testify.
Thank you, Lori. Next, common cause.
Good afternoon, Chair, Vice Chair, members of the committee. I apologize, I was on another hearing. I'm assuming we're on SB
111.
Thank you so much.
111.
Thank you so much, Chair. We had provided written comments on 2111. While we understand the importance of saving funds and moving to online publications, we are very concerned that many of our people do not have access to broadband and are not familiar with navigating technologies. So we are concerned with only having publications online, and those are the gist of our comments. We have worked with the State Department of Health in providing amendments, and I understand those were submitted as part of the testimony with Department of Health. Thank you very much for your indulgence with my testimony.
Sandy.
Thank you.
We have one individual, Peter Fritz, in opposition.
I'm here.
Oh, you're there. Okay.
Yes, as I mentioned in my testimony, I am opposed to this bill because it will discriminate, or very most likely discriminate, against individuals with disabilities, as well as kupuna, as well as the fact that many of the people in the digital divide are now using smartphones which have extremely small screens. So that's an additional obstacle. Authenticity is a concern because when you want to authenticate when something was actually published, you can do that easily in a newspaper, but you cannot do it very easily with something that is published online. And I think, if anything, all the issues and all the discussion about COVID and students having to try and access the internet drives home the point that there is a significant digital divide that could prejudice a number of people. Thank you for the opportunity to testify.
Thank you. Okay, anyone else wishing to testify? Okay, members, any questions? Okay. We have written testimony then from the following: from Office of Enterprise Technology Services in support, Budget and Finance Director in support, the University of Hawaii in support, Hawaii State Energy Office in support, Hawaii Tourism Authority in support, Department of Transportation in support, and the City and County of Honolulu Department of Design and Construction in support. Okay, no questions. I'm going to move on to the next bill, which is SB 2123, relating to state boards and commissions. It requires redacting for public review certain information on the financial disclosure statements for non-paid volunteer members of state boards and commissions. Testifying on Zoom, we have the Hawaii State Ethics Commission, Robert Harris. Aloha.
Aloha, good afternoon, Chair, Vice Chair. Thank you for the opportunity to testify. Normally I just stand on our written testimony, but I hope you don't mind if I just take a few seconds to clarify, I think, some misunderstandings. Briefly, all employees, which the Constitution defines to include boards and commissions, are required to file financial disclosures. However, 18 high-profile boards and commissions are required to file that these financial disclosures are essentially made public. However, there are protections built in to try to protect those persons' privacy, which include, for example, not disclosing the individual's dependent children's names, siblings' names, property address, etc., including also that if they are reporting any type of financial interest, whether it be ownership of a business or if it might be a debt owned, those reports are put into tiers. So sort of, general categories of high, medium, low, and I'm exaggerating a bit for the sake of simplicity, but in our testimony, we actually list the different tiers. So there is definitely some level of attempt to try to protect privacy. Of these 18 high profile boards and commissions, our understanding there's only one vacancy, whereas a lot of the testimony talks about over 300 vacancies. Those deal with all the boards and commissions that are not public. And again, it's an important distinction to make. Again, understand that there is a balancing test here of sort of transparency versus trying to make it easier for people to apply and be on boards and commissions. And that is inherently something within the legislature's kuleana to do. However, the Ethics Commission has taken a position of essentially supporting more transparency and believing that that helps empower more confidence in government, more confidence in the decisions being made. If you do decide to move forward this bill, we would note that there is both a cost to reprogramming the current online filing system to allow for sort of this unique class of individual. And in addition, there will take some time. So we'd encourage you to make this applicable a year out and would consider trying to fund the actual additional cost to reprogram the existing system. Thank you for the opportunity to testify. Happy to answer any questions you might have.
Thank you, Robert. Next, the Association of Emeritus Regents, James Lee.
Present, Chair.
Next, Kamka Sanima. You still here with us? Okay.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We oppose SB 2123. We don't think that it serves any good government interest to redact the public records for non-paid volunteer members of state boards and commissions. The public trust in our government institutions have been undermined enough already, and this will further fan the flames of distrust in our government institutions, boards, and commissions. We again oppose this measure and ask that you hold it indefinitely. I'm available to answer any questions. Thank you.
Thank you. Anyone else wishing to testify on this measure? Any questions, members? I do of Robert, Ethics Commission. You mentioned that there already is requirement of all of the boards and commissions to provide information on their income, their credit, and so forth in 8417. So this, can you clarify then? This is just redacting the amounts. Is that correct?
Correct, Chair. I apologize, I can't turn my video back on. The information would still be filed with the Ethics Commission, but what we would post publicly would be redacted under this bill.
And what does the commission do in terms of, I think, providing information to the public so that people who are applying for various boards and commissions, especially these 17 high profiles that you call them, so that they feel that there's not such an intrusion into their privacy and their interests in terms of what they own and what they're worth and their property and their dependents and where they're located and so forth. Can you provide some information on that?
Sure. Briefly, we have both a quick guide as well as a filing guide. Both are available at the time that the individual files their financial disclosure, which does list out exactly what information is going to be public and what won't be, as well as try to make the process easier. That being said, I think by the fact, again, reviewing some of the testimony, it's clear, not trying to undermine the legitimate, argument that individuals are making on this bill. There's definitely some misinformation going around as well, which would like to try to use the opportunity a bit to clarify. But again, for example, children's names are not posted publicly, and there's legitimate, reasonable privacy reasons why that's so. And so again, I think one of the things that we need to do is probably try to make sure as a part of the governor's nomination process, potentially trying to make our quick guide available at that time. So if people are interested in applying, can see that information at that time.
So the Ethics Commission does receive all the information, including the specific income, or at least the brackets or the tiers, as you call them, information on all items in, what is that, 84-17F. So everything
Correct.
comes to the commission. It's just what is being redacted for public review is just the income. Is that clear? Is that, that's what this bill does?
It's all amounts. So it's like debts owned, business, amount of an interest in a business, et cetera. So slightly bigger than income, but correct. The amounts would be reported to the commission, but not publicly posted.
Okay.
I do want to stress, obviously, that particularly for the high profile boards and commissions, in determining if there's a conflict of interest, stakeholders are probably in a much better position to decide or to understand if there's a conflict. The Ethics Commission at best would be able to see something sort of in hindsight after a decision had been made. And in that situation, we would potentially be looking at doing a fine or something, but we couldn't necessarily undo the conflict of what had already occurred.
So you would get these statements once a person was appointed, and then see whether there's a conflict. I suppose in decision making, that's when you would see whether there was a conflict in terms of what they owned or had interest in.
We would receive it at the time, you're correct, at the time of appointment, and then on an annual basis thereafter. However, we don't have the capacity, for example, to review the agendas for every board commission or to sit in on every hearing to sort of understand what's going on or who's involved. The stakeholders are going to be in a much better position to sort of understand or recognize there might be conflicts. And we've heard anecdotal reports of situations, which in part is what I think led to the creation of this original statute, particularly with the Board of Regents, and that I think that's kind of a good example, perhaps, of, again, we can try to police stuff afterwards, but the participants at the Board of Commission are probably going to be the ones most likely or in the best position to determine if there's a problem.
So if you receive a complaint from the public about someone's decisions related to their interest, then you would be investigating that based on
Absolutely.
Disclosures.
Correct.
Okay, Senator De La Cruz has a question.
Yeah, I think though the affiliations and the loans, that's all still public though, right?
Correct.
It's just that the amounts are redacted. So the public could see if there's a conflict just from looking at who they're affiliated with, or the other members. And all that. So I don't know if it's actually after the fact, because the affiliations and the companies should all be named.
Yes, but Vice Chair, the but is that the test for conflict of interest if there is a substantial financial interest, which has not yet been defined. Again, arguably anything that's disclosed is a substantial financial interest, and so that would answer your question absolutely. But I could see a board commissioner making the argument that a small ownership is not a substantial financial interest, and in that case, they may actually want to reveal, hey, I only have $3,000 of interest in this large company. I'm a little bit splitting it hairs, Vice Chair. Your comment though is well taken.
Yeah, so I think in the legislature, the ethics rules regarding the legislature, I think I was just reading that there's a minimum amount of ownership that if the legislature had, if a legislator had, they're not exempt from, or the companies that they're affiliated with, they're not exempt from participating as long as they follow the exact same rules as everybody else in regards to procurement and everything. So I'm not sure if we could take that section that guides the legislators with conflict of interest and allowing to, and also include it in this then, if that's the case, where there was some more guidance on that specifically what that threshold is. I can put
Robert, yeah.
Yeah, so
So-
the
so what-
legislature regulates itself on conflict of interest. It's excluded from the state ethics code. And so understood, you could probably try to look at language. Again, the current test is substantial financial interest, and that is something that can be defined at some point.
But don't you have sort of what we have to disclose as legislators, the candidates have to disclose. Well, I think that's what Senator Delac was just talking about, is that we use the same language. And then you would get all that information, the Ethics Commission, but we just redact for the public view the amount.
Correct.
So that could be a possibility, to give some standard that would be the same across the board.
So again, there are standards of anything over a certain amount gets reported. And again, it's typically $3,000, I believe. And so, that would be what would be seen by the public, just redacted. They would just see an interest in that. I think that's what the vice chair's comments were.
Okay, great. And so, I think that's all I have.
It's
Yeah.
84-13, the fair treatment. So I don't know if we can include that maybe in there.
Mhm. Charles, can you get 84-13? What do you need? 84-13.
So that is essentially the language that exempts the legislature from the ethics code. So that language in there basically says if you're acting in your official capacity, you're essentially exempt from the ethics code. I would not necessarily recommend that.
No, not the whole thing. I'm just talking about where
Standards.
oh yeah,
So nothing, if the language you're talking about is nothing herein shall be construed to prohibit a legislator from introducing bills and resolutions. That was, sort of in deference to the legislature being a, body. So anything done in your official capacity is exempt.
is that the one?
So I wouldn't
No, wait,
necessarily
there's one,
recommend that.
there's a section somewhere, I'm not sure if it's the fair treatment, where I know if a legislator was somehow is working for a company, and the company, that doesn't mean the company cannot do business with the state. There's a threshold where they still have, where you can and cannot.
Sure. So I suspect that's in your Senate rules, respectfully, and that you have your own rules governing conflicts of interest. So here there would be nothing necessarily prohibiting a company from interacting business with the state. It's just that board or commissioner, if they have a conflict of interest, couldn't take official action. They couldn't vote on it, essentially, in this case.
Doesn't 87-17F have all these requirements, but it has amounts? That standard is for candidates, but it could also be for all board members, right? I think does it exempt board members? 87-17F, that section that lists income and credit and.
Yeah, so that is the standard that currently applies. And so, for example, if you see in that section 84-17 F for the name of each creditor to whom the value of $3,000 or more. So that's exactly the current financial disclosure requirements.
So everybody
all employees
submits that.
Currently submit that. For these boards and commissions, essentially it's just now some of that is public.
Okay.
So anything
all
below
of that,
$3,000 is not reported. And we also, for example, exempt credit card debt and some other things.
So that is required of everybody now, candidates as well as employees and boards of commissions. So, but all of that comes to the Ethics Commission.
Correct.
Okay. Any other questions, members? Thank you, Robert. We're going to move on.
Aloha.
Thank you. Aloha. Okay, next is Senate Bill 2143 relating to boards. And this is board meetings. Requires each state board to make its board packets publicly available at least 24 hours prior to the board's meeting. Testifying on Zoom, Office of Information Practices, Cheryl Kakazu Park, are you on?
Yes, I am. Can you hear me,
Aloha.
Senator?
Yes, we can hear you.
Oh, good.
Hmm.
Hi, everybody. Good afternoon, Senators. I provided detailed written testimony as well as proposed amendments. So I'll just summarize everything and say, I hope I got your intent right in making these amendments, proposed amendments, and simplifying the bill, clarifying it so that it doesn't have the internal inconsistencies and confusing language anymore. But one thing I would like to also respond to is the suggestion by a couple of other testifiers to add further amendments to this bill. And OIP, which, you know, we are very supportive of the disabled community, the persons with disabilities. We try to provide fully accessible documents on our own website, but those are requirements that we follow under the ADA's requirements, or other disability statutes. And it's not appropriate to add those kinds of requirements into the Sunshine Law for OIP to administer when OIP doesn't have authority over those kinds of issues and is not able to enforce them. So I wouldn't really object to adding in any kind of accommodation type of or disability type of language into the Sunshine Law itself. You know, anytime you add anything into the Sunshine Law, it's just another way for the boards to possibly trip up and, you know, not be able to do their work. So I would be really cautious about what types of amendments you want to see added into the Sunshine Law. Thank you.
Thank you. Next is National Federation of the Blind, James Gashel.
Yes, thank you, Madam Chair, Vice Chair, committee members. James Gashel, National Federation of the Blind. I'm going to stand on our written testimony. We've asked for 2 amendments, both having to do with electronic access. They're very important for accessibility, and we definitely want to feel the aloha of OIP. We don't want to impose any burdens on OIP, but we think these amendments would not be burdensome and we would be consistent with OIP's purpose and willingness to consider meaningful amendments. Mahalo.
Okay, mahalo to you. Next is Common Cause, Sandy Ma. Hi, Sandy.
Good afternoon, Chair, Vice Chair, members of the committee, Sandy Ma for Common Cause. We support SB 2143. We think this is necessary to provide for transparency and accountability for the public when observing board meetings. What we have seen is that a lot of board packets are not provided in advance and provided at the last second. And so when the public is trying to participate at a board meeting, we do not know what the board will be reviewing. And then our testimony, our written testimony is required to be submitted in advance. So we are providing written testimony blindly and are not able to provide meaningful testimony. And then when we do get the board packet, we realize we've provided testimony inaccurately at times. And then we would like to provide the opportunity to provide oral testimony after presentations. This is because when a presentation is made during the middle of an agenda and we are limited to testifying at the beginning of the agenda, then we cannot provide meaningful comments to the board, especially when we don't get the board packet, and especially when we are limited testifying at the beginning of an agenda. And so then again, the board cannot benefit from public comments. And so this is why we think that this bill is especially useful for the public and participating before boards and commissions. Thank you for allowing Common Cause to provide comments on this bill, and I'm available to answer any questions. Thank you.
Thank you, Sandy. And we have one individual, Peter Fritz.
Good afternoon, Chair, members of the committee. I'll stand on my written testimony, but I'd also like to add that I believe that transparency applies to everybody, including individuals with disabilities, and that there is a responsibility to provide accessible documents. That document exists outside of OIP, but it's not something that OIP can really ignore its responsibility to this segment of the community. Thank you.
Thank you. Anyone else wishing to testify on this measure? Okay, questions? Anyone for the testifiers? I'm going to go back to Cheryl. Cheryl, National Federation of the Blind, and also I think Mr. Fritz asks about these electronic files, including a screen reader accessible format. You say you follow ADA and ADA requires it. So what would be the harm in putting it in law, or how? You know, I know that
put it in the disability statutes and have the disability people, whether it's DCAB or Hawaii Civil Rights Commission, whoever it is, enforce it, because we don't want to have to enforce it under the Sunshine Law when we don't really know all the technology or what legally is a reasonable accommodation, or, you know, I mean, I don't know all this stuff. We're just trying to follow the disability statutes when we're doing it. We're not trying to follow the Sunshine Law when we put things up on our website. That's governed by a whole different area of law, not Sunshine.
So understand though, you know, on these agendas, they do say that, you know, if you need assistance, accommodation, that the state will provide it, or that the agency will provide it.
The Sunshine Law just requires us to put on just requires boards to put on their notice that you can ask for a reasonable accommodation. It doesn't require OIP itself to enforce any violations of the reasonable accommodations, you know, or determine whether the people were provided reasonable accommodations. The only thing we can say is, well, you didn't have the notice on there, so you violated the Sunshine Law notice provisions. That's all we do. We don't get into whether it was a reasonable accommodation or not. And we don't get into like, well, where did you provide it? What kind of technical standard did you use? We don't know any of that part.
But could you provide some kind of notice of there being the ADA standard, or where they could go if they weren't getting accommodated?
Well, it's already on there that, you know, you can go and ask DCAP. That's where we got the language from in the first place, that we recommend to boards to use on their minutes. So we work with DCAB and we defer to them, or, you know, HCRC or whoever else might be actually in charge of those kinds of laws.
Okay, any other questions of Ms. Kakazu part? Okay, thank you, Cheryl.
Thank you.
Okay, moving on to SB 2336, relating to, oh, you're up again, OIP. Requiring OIP to resolve open meeting, open record complaints through either a legal determination on whether a violation occurred or guidance on the relevant legal requirements.
Yes, thank you. We fully support this bill because contrary to the statements of opponents of this bill, current law does not give OIP the discretion to provide informal guidance instead of full-fledged opinions in appeals. And note too that this section only refers to cases that OIP categorizes as appeals or maybe requests for opinions. And the opponents are citing to other provisions of the law that do not address what this bill does. Because OIP currently lacks statutory discretion to determine the best way to handle its appeals, all appeals that the requesters insist on having legally determined by an opinion remain in our backlog. And as we attempt to resolve the oldest appeals first. So it actually hurts some of the people who have opposed this bill because we kind of get to some of the types of appeals that they would like to see resolved because we have other appeals pending before it. Sometimes they take just so long to get through every minor point that they bring up, whether it's substantive or important, of any public interest or not, just to give them that opinion that they are entitled to under the current law. Now, if we had this bill pass, we'd have some flexibility in those cases. And we're not talking about every case. We're talking about, some of those cases where people do not understand the types of cases that we see at OIP and how, involved and detailed they can be and if we have to write an opinion addressing every single point brought up, it takes a long time and it's not really necessary. These cases do not all resolve issues of great public importance or interest. So if we have this flexibility to say, here, we're going to give you written guidance, we're going to address your main points in appeal, this is how we think the result would be, and good luck, saving our limited resources and time to answer and provide opinions on those matters that really do involve the public interest, and move our backlog along. At one point, just before COVID, we got it down to the lowest level ever. As long as I've been here, we brought down our backlog, but because of COVID and the loss of experienced staff, we haven't been able to address them, and the backlog has ballooned. It's gone up sizably, and this bill would help us to address some of those cases, not require us to spend a whole bunch of time on cases that are not important to the public, and really get to more of the cases that we want to resolve with opinions. So that's why we support this bill, and would be willing to provide agree to an amendment that would clarify that the guidance has to be written. If you need further definition of what we mean by guidance, would be happy to provide that to you. Thank you.
Thank you. Okay, I think that's all I have. Anyone else wishing to testify on this bill 2336? Okay, that's all I have. I have written testimony from the League of Women Voters in opposition, Civil Beat Law Center in opposition, Society of Professional Journalists Hawai'i chapter in opposition, Common Cause in opposition, and one individual, Lynn Matuso, in support. Members, any questions of, I guess the only person here, Cheryl. Okay, most of, you've seen the testimony. The opposition is that it goes against transparency, accountability. If this bill passed, what is the difference between a ruling and guidance? I mean, is guidance sort of you're doing it behind the scenes and we don't know what the decision was or what the recommendation was? How does it differ? Why do you want a guidance instead of doing this ruling?
Well, what we'd like to do with guidance is provide written guidance, first of all, and discuss all of the major legal and factual issues that are brought up in an appeal. But some of these appeals go into little minutia, factually or legally, that take a lot of time for us to investigate and address, and are ultimately not even important to the resolution of the case. We don't want to have that, to spend that time addressing all the little minor details that are not important. We want to save our time to instead move on to to first of all, quickly resolve these types of cases, and then be able to move on to the rest of our backlog and address those cases that need opinions, where we do address every single issue, legal and factual issue that is raised on appeal. And so we want to put our resources where they're best utilized.
So give me an example of these minutia cases that come before you, and why these are different than what you call the cases that rise to level public interest significance.
Okay, I have with me staff attorney Jennifer Brooks, who has worked on some of these cases and can maybe explain to you
quickly, because we have a lot of stuff on our agenda. So just to see, what are you going to give us if we go with the guidance route in resolving cases and still be transparent?
Senator, I think what we would be picturing is something akin to what we did during the pilot program that OIP undertook at the legislature's request a couple of years ago, where we were experimenting with issuing written guidance to see if it would resolve appeals. And you might call it an 80% solution. We're saying we think this is what's going to happen. And so far, every one of those we've done the actual opinion on later, that's what's happened. But an example of one of those, a guy was seeking camera footage from an office building. Agency didn't have it anymore. So it was clear that he wasn't going to be able to get it because they didn't have it anymore. However, he had issues with the agency staff and raised a whole lot of points about, well, how do they not have it anymore? When exactly was it automatically deleted? Should somebody have known first? What was the email trail? That took a lot of time to look into for the actual opinion, but it didn't change what we knew would be the outcome with the guidance. That's the sort of thing we're looking at issuing, just the guidance without having to do the extra work to do the appeal and nail down every last issue.
So is it appealable, or what? So person who says, okay, yeah, so you did this, but you didn't do that, and it rises, I don't know, to other people having the same problem with that agency. I don't know. I'm just hypothetically, how does it rise to a ruling, or that's it? What is the accountability transparency that the public wants to know that you gave it a fair shake?
Well, first of all, for any individual, there's always the option to go to court with these. So if we issued guidance, that wouldn't cut someone off altogether. Now, obviously, we're using our sense of something to say, we don't think this is something that's repeated. We think this is perhaps a personal grudge between the person and the agency. But let's say we're wrong, and let's say that the person is coming back saying, look, same thing happened again and again, or other people are coming in and doing this, spotting the same problem. Then obviously it would rise to something where the level where what we initially took to be kind of minutiae, we realized, no, this is a significant public concern. This isn't an accident, this is a pattern. And, at that point, I think we would say it's no longer appropriate for guidance. This needs to be an opinion. Obviously, it's a judgment call on our part. So in that sense, we're asking for the legislature's trust in giving us this power.
So Cheryl mentioned that she could put together a definition of guidance so that we would feel more comfortable that it was given a fair assessment and review. What does that mean? If we had a guidance that was written, would we be able to see the guidance? And do we see the ruling as well, so that we know these are cases that set somewhat of a precedent? I guess not the guidance, but what would we see in a guidance versus a ruling? Senator Dela Cruz also has a question.
Well, I was just going to ask Cheryl, can't you just make the guidance public?
Yeah, it is. We're going to put it in writing. It's public. It's just that maybe we won't address every single little detail that they bring up, like we do in an opinion.
Okay, let's say you guys end up posting the guidance. Someone actually wants to go through the process. You're still going to have to do it. Don't you think that's more work, because you're going to do the guidance? Someone actually makes a complaint, and then you're going to actually have to do the whole process anyway?
No, this would be how we would resolve that complaint, that appeal to us. It would be through written guidance, which we're saying is a little less than our opinions. Our opinions, we go through a long, drawn out
Yeah, but the
process.
opinions have force and effect of law.
Well, they are subject to a very high standard of review if appealed to the courts. So that's why we take great care and a lot of time.
But I thought the courts ultimately, to some extent, have to defer to your guys' opinions.
They should. They have a high standard of review to overcome before they overturn us on the facts or the law. Typically, supposedly, that doesn't always happen, as you know.
Yeah, but that's in
that doesn't happen with guidance, though. It won't happen with guidance.
Yeah,
right?
with guidance, they can just take it to, but you know what? A requester, even with our opinions, they can just say, I'm going to take it to the court and it's brand new. They're not bound. The requester is not bound. The agency is bound, but not the requester, assuming the requester is an agency. You know, the requester has a much lower standard of review, and the requester can always go to court. They don't have to come to us. And even if they get an opinion they don't like from us, they can still go to court.
The guide, so the guidance is going to be public as once it's issued.
Yeah. I mean, we're not going to post it, but we will make it available upon request.
Well, do you make
it's public? Huh?
Do you make your opinions public?
Yeah, our formal opinions are fully public. We post it up.
So why can't we make the guidance posted?
The memo opinions, well, like the memo opinions, we post a summary, and if people are interested, we provide them with the full opinion.
Okay, so can you do, because it seems like the concern is the transparency of the guidance. So can't you summarize the guidance and post that?
We could.
Okay.
We could summarize it and post it on, just like we do with our informal opinions.
Okay, so can we include that in the guidance, that it be posted? Also, a summary of the guidance posted on your website?
I don't know why you have to do that by statute. We'll just do it for you.
Okay, we'll put in a committee report just so you do it.
Yeah, okay. No problem. Because we post everything that we have on our website. So we're fully transparent.
You don't post the guidance.
Well, we haven't written any guidance yet.
That's right. But you will post the guidance.
Yeah. Uh-huh.
And it will be written.
Uh-huh.
Okay. All right. Any other questions? Okay. Thank you. Okay. The next one is SB 2301 relating to boards and commissions. It requires the governor to appoint an individual to fill a vacancy within all boards and commissions within 180 days. It limits holdover appointments to the end of the legislative session following the expiration of the member's term, and requires department heads to inform the governor of any vacancy and conforms requirements regarding holdover members of the Hawaii Tourism Authority to the requirements of all other state boards and commissions. I might say that this and the following bill, SB 2477, relate to boards and commissions and holdover appointments. So first up is, I think we have just one written testimony in support from an individual. I don't see anyone else wishing to testify on this bill. Okay, so I'm going to move on to the next bill, which is similar but different provisions. SB 2477 relating to boards and commissions provides for the term expiration of a holdover member at the end of the regular legislative session following the expiration of the member's term, authorizes the president of the Senate to nominate a successor if the holdover member's term is set to expire and the governor fails to nominate a successor. We have no one on Zoom unless someone has come on to testify, which I don't see. And one written testimony in support from IBEW Local. I'm going to move along since I don't see anyone wishing to testify in this measure. Next bill is 2368 relating to informal meetings. It exempts members of the county council from the limitation on the number of members that may attend an informational meeting or presentation open to the public as a permitted interaction. First up is Office of Information Practices, Ms. Park.
Okay, we oppose this bill. We already enacted it, legislature already enacted a guest meeting provision back in 2014, which was made permanent in 2016 and already allows all members of a county council to jointly attend community meetings while providing appropriate safeguards for the public interest, which this bill would strip away essentially and render moot. That's why we oppose this bill.
Thank you. Common cause. Sandy, still up. Sandy, Ma.
Good afternoon, Chair, Vice Chair, members of the committees. Sandy Ma for Common Cause Hawaii. We also oppose SB 2368. The Sunshine Law already allows for what is trying to be done for SB 2368. We don't understand the need for this measure. Thank you, and I'm available for any questions.
Thank you, Sandy. Anyone else wishing to testify on this measure? We have written testimony from League of Women Voters in opposition, Civil Beat Law Center in opposition, and the Society of Professional Journalists Hawaii chapter in opposition. Okay, we're going to move on.
Can you say one more thing?
Yes.
I forgot to say.
Yes, okay, please.
Ironically, this proposal would actually limit other boards' ability to use the same informational meeting provision to keep abreast of professional developments. So not only would it allow the county councils to run amok, but it would prevent other boards from using it legitimately. So just another point. Thank you.
Thank you. Okay, moving to, I do have one question. Cheryl or Sandy. The Center for Public Interest is not on this Zoom, but they testified that House Bill 2026 addresses this problem as a better bill. Do either of you have any knowledge of that?
House bill. Oh, I think that was
something that they worked together. You guys all worked together.
Yeah, there was another
that?
bill that was heard in the House, I think. I don't know the bill numbers.
Okay.
But that's one where the different good government groups and county councils got together.
Address the problem that the county is having.
Yeah, so that's a better bill.
Okay.
We were neutral on that.
Okay, and Sandy, you have any comment on that?
Yes, we did work together with the county council, and there was a representative from OIP working on the bill. She had reviewed the bill as well.
Okay, good. All right, thank you.
Thank you.
So the last bill we have is SB 3038 relating to Information Privacy and Security Council. And this amends the current section 487N-5A to allow for designees to act on behalf of the members of this Information Privacy and Security Council. Currently have problems getting quorum. So I have on Zoom Office of Technology Services, Doug Murdoch or staff. Is Doug on?
Doug's not here, but I'm speaking on behalf.
Yeah. Hi, Vince.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Vince Huang from the Office of Enterprise Technology Services. On behalf of the Chief Information Security Officer, we stand on written testimony, and I'm available for any questions. Thank you.
Okay. I don't think there's anybody else here. So members, any questions of Mr. Huang? I do. What is the council? Really quickly, briefly. Does it meet regularly and you can't get quorum?
Right. This is a council that consists of state agencies and also counties, and we meet on a regular basis. And because of lack of resources, there are times where one of the members are not able to attend, and because of the membership levels, we risk not meeting quorum and missing a meeting and having to reconvene in a future month. So,
this is mostly like cybersecurity stuff.
It applies both to cybersecurity and how we can interact and collaborate across, and also identify practices on how to improve privacy for the local and state agencies. Yes.
Okay, thank you. Thank you for your work.
Thanks.
Okay, members, I would like to call recess at this time. We're going to return for decision making. If we can go into breakout room. Thank you. Aloha, everybody. We're back for decision making. Let me note that all the bills that pass out will include necessary technical non-substantive amendments if needed. The first bill is SB 2111 relating to public notices. The chair's recommendation is to pass with amendments, taking the Department of Health recommendation to add section 2, allowing posting of electronic calendars, provided the state and county conduct and document an evaluation and provide their rationale to justify online posting of notices, especially when they affect those with limited broadband or technology experience. And adding in the committee report that they should post as practicable and following ADA screen reader accessible format as requested by the Federation, National Federation of the Blind. Members, any discussion? If not, chair votes aye. Vice Chair Dela Cruz.
Senate Bill 2111, recommendation is to pass with amendments. Chair votes aye. Vice Chair votes aye. Senator Chang.
Aye.
Senator Gabbard.
Aye.
Senator Favela. Excused. Recommendation adopted.
Thank you. Senate Bill 2123 relating to state boards and commissions on financial disclosure. The chair's recommendation is to pass with amendments, taking the Ethics Commission recommendation to change the effective date to January 1, 2023, and also including in the committee report that this bill reflects the balancing of personal privacy interests of those who voluntarily serve with the public right to know and to prevent any conflict of interest in decision making. I also want to include that the Ethics Commission will redact only the amounts and reiterate that section 87-17F127 includes all the information that should be submitted to the Ethics Commission. And that the Ethics Commission is also charged with working with the agencies to train their boards and commission members and staff on these financial statements and conflict of interest of their boards and commissions. So with that, the chair votes aye. Vice Chair Dela Cruz.
Senate Bill 2123, recommendation passed with amendments. Chair votes aye. Vice Chair votes aye. Senator Chang.
Aye.
Senator Gabbard.
Aye.
Senator Favela.
Aye.
Recommendation adopted.
Thank you. Senate Bill 2143 relating to board packets. The chair's recommendation is to pass with amendments, taking OIP recommendations to provide a fuller definition of board packet and placing in the definitions section of the law, making it clear that boards are not required to use board packets, but when they do, they must be available for public review at least, and we're going to increase this to 48 hours prior to the meeting. And 3, provide the boards shall not limit testimony solely to the beginning of a board's meeting. We also will include in the committee report the same thing on board packets, electronic filing, B screen reader accessible format. Chair votes aye. The recommendation with amendments. Chair votes aye. Senator Dela Cruz.
Okay, Senate Bill 2143 recommendation is to pass with amendments. Chair votes aye. All members present, any objections, any reservations? Recommendation adopted.
Thank you. Senate Bill 2336 relating to the Office of Information Practices. And this is to resolve open meeting and open record complaints through legal determination or guidance. Chair's recommendation is to pass with amendments to provide a definition of guidance as provided by OIP to assure that it is written and that it requires that and resolves the complaints. And we also would like to include that the ruling and guidance by the commission be posted on their website. The chair votes aye. Chair Delacruz, Vice Chair Delacruz.
Okay, Senate Bill 2336 recommendation is to pass with amendments. With all members present, any reservations, any objections? Recommendation adopted.
Thank you. Senate Bill, I'm going to take Senate Bill 2301 and Senate Bill 2477. Okay, they're both having to do with holdover appointments. The chair recommends to pass Senate Bill 2301 with amendments. It will insert the contents of Senate Bill 2477, which creates a new section D in section 26-24, allowing the Senate to nominate and appoint a successor if the member's term will be exhausted and there is no appointment by the governor, and expires holdover terms at the effective date of the act, and with technical amendments. Chair votes aye. Vice Chair Delacruz.
Okay, Senate Bill 2301 recommendation is to pass with amendments. With all members present, any reservations, any objections? Recommendation adopted.
SB 2477, as I said, this will be deferred as the contents are now in Senate Bill 2301. Senate Bill 2368 relating to informal meetings, exempting the council from limitation on the number of members to attend informational meetings. This is, Chair recommends that this be deferred. Senate Bill 3038 relating to Information Privacy and Security Council, the Chair's recommendation is to pass as is. Chair votes aye. Vice Chair Delacruz.
Senate Bill 3038 recommendation is to pass unamended with all members present. Any reservations, any objections? Recommendation adopted.
Thank you. With that, we are gaveling out of the 310 hearing and gaveling into our 315 decision-making on a short form bill. This is on SB 2940. It's a short form bill relating to government. The chair's recommendation is to pass SB 2940 with amendments and recommit it to this committee. The amendments are to insert the contents of the proposed Senate Draft 1 relating to telework, which was earlier emailed to you. Any discussion, members? If not, chair votes aye. Vice Chair Delacruz.
Senate Bill 2941 2040 recommendation is to pass with amendments. With all members present, any reservations, any objections? Recommendation adopted.
Thank you, Vice Chair. Thank you, members. With that, this concludes the Government Operations Committee hearing. Thank you, everyone, for your participation and your patience. Aloha.